Members, good morning. We've formed a quorum and it's already past our scheduled time. May I call to order the meeting of the Bills Committee on Stamp Duty Amendment Bill 2013. This is our 10th meeting. According to our agenda, the first item is to discuss with the administration the bill and also to discuss administration's response to members' issues raised at the last meeting. We have CB 1060-1314-02 administration's response. And let me declare interest as usual. I own properties and I am an accountant, and the company I serve provides various types of advisory services on taxation for my clients, and I'm not involved in such business. Mr. Wang Tingguo, I make the same declaration as before. Mr. Tommy Zheng, Mr. James To, Mr. Leung Chi-Chang, declaration, the same declaration we've made in the past. Since the paper is related to the clauses we're going to scrutinize, so can I invite the administration to walk us through the administration's response so that members can first discuss these issues before we continue with our cross-by-cross scrutiny. Over to you, DS. Thank you, Chairman. We were scrutinizing the bill clause by clause at the last meeting, and then some related issues were brought up, such as exemption arrangements. In our response paper to the administration, I will highlight what's in the paper. We said that in 29AH, exemption for a person who is a minor or mentally incapacitated. As we said at the last meeting, the exemption for a trustee or guardian on behalf of Hong Kong PR who is a minor or mentally capacitated person, because it was withdrawn in the 2012 bill, and therefore the issues should have been addressed. So in this bill, we are talking about people who own more than one property. They're required to pay stamp duty. Because the objective of the bill and also the exemption issue were already dealt with in the 2012 bill, and therefore we're not going to withdraw the exemption for persons who are either minors or mentally incapacitated. So we'll follow the arrangements in the 2012 bill. The ILD will require documentary evidence set out already in this paper. And members also asked about the criteria for determining whether a property is a residential property or non-residential property under Section 29A1 of the ordinance. Now, these will involve a number of clauses we are going to study. And the criteria is based on Section 29A1 of the Stamp Duty Ordinance. So when the ILD refers to any of these instruments and there is nothing to say that the property cannot be used as a residential property at any time, then the property is deemed to be a residential one. And that's the criteria used in the section. And we have tried to provide some examples in our reply. Of course, we can't be exhaustive. However, we hope that it will assist to explain the criteria for determining whether a property is a residential one. And regarding 29AL and BD, that is the question of a replacement property. We have also considered proposals by members as to whether we need to set a limit on the size and of a replacement property, and we have considered the arrangement in the 2013 bill in order to avoid affecting property owners, causing unnecessary restrictions or inconvenience. We intend to follow the Stamp Duty Amendment Ordinance 2014. And the last question is about exemption arrangements under the doubled AVD regime. Whether this is in line with the arrangements under the existing SSD and BSD regimes. In Para 10, we have set out some arrangements, exemption arrangements, and also the clauses for referencing. So, we have considered the SSD and BSD regimes, which offer where there are clauses about a mortgagee and also arrangements between close relatives. And the last issue is about exemption arrangements involving the acquisition or transfer of a residential property between close relatives. We're going to touch on this issue in the clauses to be scrutinized. In Annex 2, we have set out various scenarios to illustrate to illustrate the arrangements, and I'm sure this will help us in the deliberations of related clauses. All right, the paper involves a number of issues. First, members, do you have any questions on the part about minors and mentally incapacitated persons? Mr. James To. All right, 4 minutes each, as usual, okay? Thank you. I have a question on Para 4. According to Para 4, some instruments will be required. All right, I will not talk about the part about in relation to the actual circumstances.
Okay, you talk about documentary evidence, such as a birth certificate. This will help to prove that the mentally incapacitated person is a PR. But a valid and legally binding trust instrument, at the time of purchase, if it is done in the form of a trust, would that document suffice? Yes. Can I ask the IRD to answer the question? Yes, please be brief and tell us about your actual operation. Thank you, Chairman. In the agreement for sale and purchase or on the conveyance on sale, if it is written clearly that the nominal buyer is holding or buying the property in the capacity of a trustee on behalf of a minor or a mentally incapacitated person who is a PR, then that can constitute a trust instrument. And I think that's clear. That's much more clear. If a person can submit some evidence to show that the minor or the mentally incapacitated person is a PR, plus there is a conveyance on sale, so the property is bought on behalf of this person, then they can already enjoy the exemption. You talk about the actual situation. You talk about funding documents to prove the source of funds. If it is not a minor or the incapacitated person, if it is issued by the trustee, that will suffice, isn't it? When you talk about source of funds, I don't get it. Does it mean that it should come from the minor? That will be quite unimaginable. Or should it come from the mentally incapacitated person? It is not possible for you to ask for something like that. So taking the paragraph as a whole, it will be very much easy for people to abuse the arrangement. That is my conclusion, Chairman. If that is the understanding, I hope the administration will consider doing something about the 2012 bill. You do not have necessarily to follow my proposal, but you must talk about a trustee or guardian who is appointed by the court to prevent abuse. I think Mr. To has already put forward that viewpoint many times. I'd like to ask you whether the position in the paper is your final position after considering Mr. To's concern. This is your final position, is that right? Can you give the reasons again? Thank you, Chairman. I certainly know that at the last Bills Committee, the same issue was discussed, and I understand Mr. To's concerns or worries. We believe, as it is written, the IRD has this arrangement to get documentary evidence and also to clarify who the parties are. We believe the present clauses are sufficient. Well, yes, we understand what you are saying, but it is easy for it to be abused. You can see this big loophole for abuse, but you're not plugging it. Any supplement? No. Next, it's my turn. May I refer to paragraph 3 of the paper? According to the IRD's records, since the announcement of the SSD, BSD, and the double AVD measures, there are about 30 cases where the trustees acted on behalf of holders of Hong Kong IC who were minors. In the acquisition of residential properties, there are no cases registered in respect of trustees acting on behalf of mentally incapacitated persons. In other words, there have been no mentally incapacitated persons buying property through a trustee. That's correct. About these 30 cases, well, this may not be related to your work, but then these 30 cases, they will have to pay the BSD because the bill has been supported. Well, yes, if it was a trustee, then according to the bill in 2012, they would have to pay BSD. And according to your proposal, these 30 cases now do not have to pay the ad valorem stamp duty. That's correct. Mr. To, I'd like to ask about these 30 cases. Is it that the majority of them belong to the category I pictured? In other words, I'm referring to paragraph 4, of course. I am cutting it short. There are 30 cases, not too many. Since my focus on this bill and also on the last bill has been the same, and since you have identified 30 cases, I'm sure you know some details of these 30. Let me not talk about future possible abuse. I'd like to ask about these 30 cases. Is there just a trust instrument, or do they set up very complicated trusts? Many trusts, for example, and then one would be used to buy property and the other ones would be used for daily living expenses or buying other things. So was it just done on the basis of a trust? Yes, from what I understand, the beneficiary has been the minor in all these 30 cases, and we've got the ID numbers so we know. And documents show that trustees bought the property on behalf of minors. There have been no involvement of mentally incapacitated persons. No, the question was about the trust instrument. You asked for it, so was it just the conveyance on sale? Maybe you can have a family trust, and then they will say, okay, I use the trust to buy property for a minor. In other words, these 30 cases, of course, are not exempted from paying BSD, but they are making use of this loophole. Let's say, I like to use this word, but Mr. Abraham Shah may say that is a right because we have different viewpoints. And I'm exactly talking about these cases. I'm asking you whether all 30 cases have been done on behalf of a trust document only, instead of more comprehensive trust arrangements. Who can answer the question? Maybe the ILD can answer that specific question. No, I'm not talking about the general situation, but these 30 cases, please. Chairman, thank you. A minority of the 30 cases showed the trust arrangement in the transaction documents, but in the majority of cases, this was not specified in the transaction documents, but then there was another trust declaration. Okay, so there was just the trust declaration. Why, yes. The agreement for sale and purchase or the conveyance on sale did not specify a trust, but then there was a separate declaration of trust to show that the sale and purchase was done on the basis of a trust. This applied to the majority of cases. Now, if that declaration of trust only talked about the property buying instead of other things, is that the case? Right now, I do not have the information at hand. Chairman, can you ask them to dig up the information? Whether or not it is a declaration of trust or a conveyance of sale with a declaration, it is just one piece of paper. They can just set it up and make use of the loophole. Well, we understand, Mr. To. You repeated that viewpoint many times. Have you finished with your questions? If that's the case, let's carry on. According to the administration, now there have been no cases of trustees acting on behalf of mentally incapacitated persons. Now, can you repeat it for our benefit? What is the definition of mentally incapacitated persons? Do you know how many of them are there in Hong Kong? Let us know the definition and which ordinance are we talking about. Thank you, Chairman. In the 2012 bill, it is stipulated in 29A3A. In the applicability, there is a definition to say that these people are mentally retarded, or that they should comply with the definition in clause or section, a certain section in Cap 136 Mental Health Ordinance. In other words, people have to refer to the Mental Health Ordinance for that definition. That's correct. Okay, shall we carry on? Any other questions on this part of the paper? Next one, criteria for determination of the property nature. Mr. Andrew Leung, first time. I'd like to know whether you have received any applications for exemption in 2012-2013 in the buying of replacement property, and how do the prices of the original property and the replacement property differ? ILD, any information? Chairman, we do not have the information at hand. What do you mean? It does not mean that there have not been any cases. Is that right? After the implementation of these duties, there would have been the buying of replacement property or the buying of property not on one's own volition. I think that's what Mr. Leung is asking. If you do not have the information, can you supply it later? DS? Yes. We will take a look. But internally, we had examined the situation, and at the moment, there has been no information showing this particular category of exemption, but we can take a look again. In other words, after the implementation of the various new duties, no owners have been able to cite the replacement property arrangement in order to be exempted from the stamp duty. Is that right? Maybe you can dig up the information and give us an answer next time. Mr. James To, what about car parking spaces? Where is it? Is it at C? I'm referring to Annex 1. Well, yes, the information will follow. Well, yes, this is under 5. There is nothing else at the end. Well, I think with regard to replacement property, the legal advisor has a view. No, I'm not talking about replacement property. In fact, para 5 also has to do with car parking spaces that we mentioned last time. Yes, I get it. Chairman, can I please answer the question? There was an example involving a car parking space. Please refer to Annex 1, under C, bracket 1 and 2. We have responded to the situation. Can you take me through it? Because I don't think I have grasped the information there. Last time, a member said that if in an instrument there is residential and also non-residential property involved, then what would be done? What is commonly seen is that if a person purchases a residential property, including, for example, a car parking space, and usually that car parking space will be regarded as a non-residential property. And what are we going to do? The principle is, first of all, the instrument would be looking at, we would look at the overall consideration of that instrument as a whole and charge duty. If the instrument includes different things, and if different exemption arrangements would therefore apply, then we will have to delineate whether the items are residential or non-residential in nature. One of the scenarios will be a person buys a residential property, including a car parking space. Usually, the instrument will just cite one consideration, or it may list the consideration of different items separately. But for the IRD will have to look at what actually is happening in order to assess the two items to see whether they can be dealt with separately or should be dealt with together. In certain circumstances, somebody buys a property, residential property, including a car parking space, and without any separate lease arrangement, and if it is paid for by just one consideration to the developer, then we'll regard it as a residential property in order to assess the duty amount. But if a person buys a residential property, but he goes for a separate agreement and buys the car parking space separately, however, these two are included in one instrument, then it is up to the IRD to decide whether indeed two transactions have taken place. If that's the case, then they will be dealt with separately. In other words, if the person doesn't have any other property, then the residential property part will be charged duty according to the old rates. But the car parking space would be charged duty according to the new rates. However, if there cannot be any separate agreement for sale and purchase, then it will be regarded as a residential property as a whole, and only the old rates will apply.
In response to the Law Society's submission, we already mentioned this point. Mr. James, or rather it should be Mr. Abraham Sheikh for the first time. Let me declare what I've already declared in the past. Para 8. I'll talk about a couple who lives together and settle in para 8. Does that mean that they're entitled to each purchase one property? Will they be affected if there are other properties involved? Yes. I think Mr. Sheikh is referring to replacement property. Yes, para 8. All right, if a property is being affected, acquisition arrangements, and if the property is jointly held, and if they have to be split, then our ordinance allows them to jointly or to separately purchase a property of their own. But if they already both own if both own other properties, would that be affected? No. This is an exemption arrangement that will not affect their entitlement. Mr. James, so you have a follow-up question? Yes. I still quite don't understand after hearing the administration's explanation, but if I may try. Annex 1C Roman letter 1 is relevant. If it is confirmed that the concerned residential and non-residential properties cannot be separately and distinctly traded. What do you mean by cannot be separately and distinctly traded? Now, if I purchase a residential property plus a car parking space, now to cite an example, do you mean that there are DMCs that where it is specified that a car parking space cannot be sold separately? It must follow a certain residential flat. Now, this is scenario 1. Flat A, first floor, is tied to car parking space A. And under the DMC, the car parking space A cannot be sold to another person. It must be tied to a flat A first floor. Or historically, when the flat was bought from the developer, car parking space A was linked. Or can the parking space be sold to anyone who lives in the same building? So I'd like to know whether here you only refer to scenario 1. Yes, scenario 1 is clearer. When now the two items must be purchased at the same time. And for the second scenario, the first-time buyer had to buy the two together. However, the car parking space could be sold to another person. No. For scenario 2, let me clarify. For scenario 2, now I'm a buyer. I purchase flat A on the first floor plus car parking space A. The current owner can choose to sell the flat to me only and then the car parking space to another person. However, he has chosen to sell both to me at the same time. Now, because the two can be traded separately, it's just coincidentally I have purchased both, and then I'm not, and then I don't fall under Roman 1. Yes. It's just that a person has chosen to buy two at the same time when in fact the two can be traded separately. So it depends on whether the two can be separately and distinctly traded. If yes, then the IRD can decide that the two are separate things. So even though they are traded at the same time, they are regarded as two separate items. Yes. So you have to affix a consideration to the flat and another consideration to the parking space. Is that right? And for the first part, depending on whether you own properties or not, you have to pay a certain stamp duty. And then for the car parking space, the AVD rate will certainly apply. Yes. The tax is always assessed according to the consideration of the instrument. However, if the two items are of different nature, then we will decide whether the exemption applies or not. And that is whether the first should apply, whether the old rates would apply or the VAD should apply. I think you should try not to cause so much trouble to members of the public, I do agree that people can speculate on car parking spaces. There was once a lot of speculation on car parking spaces. But if it's just one flat plus one parking space, and if the person only owns one flat, then do you have to make it so troublesome as to charge doubled AVD on the car parking space? Can you offer some exemption? Yes, please, because parking spaces are different from residential properties. I think if a person owns one car parking space, it's likely that it is for his own use. Well, we used different cases to illustrate how we deal with property transactions. And I think on each and every case, the ILD has to judge the facts. No, I'm not talking about that case. I already said that in scenario 2, well, both have to be separated. Please do not make confuse it with scenario 1. And Mr. To is saying that whether you can give special consideration. Yes, you should not charge doubled AVD on the parking space. Yes, should the person be affected because he owns a property? We have to consider the nature of residential and non-residential properties. A parking space is a non-residential property. So if it is a residential property plus another non-residential property such as a shop space in the same agreement, then we have to consider that scenario as well. I'll follow up later. Any follow-up questions? So the spirit is for you to decide on each and every case. And the spirit is, to put it simply, if the two items cannot be separately and distinctly traded, and if the person is buying property for the first time, the double AVD rate will not apply. So if a person with the exception of the case I just cited, if a person buys a parking space for his own use, he will still have to pay doubled AVD. Is that correct? Yes, to put it simply. Mr. Wang Ting-Kwang. We have stamp duty amendment bills 2013 and 2012. The purpose is to curb property speculation. Now, we are now talking about a parking space together with a residential property. Perhaps the administration hasn't considered the different combinations and the very complex scenarios. I don't think this is such a rare case. It's quite common. I'm a PR in Hong Kong buying a residential property for the first time, and then I don't have a car, so I don't consider buying a parking space. Now, if in the same agreement I am forced or I am forced to buy a parking space, I have no choice. But very often, in secondary or second-hand properties, a residential property and a parking space are traded separately. Because I don't own a car now, there is no need for me to buy a parking space. However, after a while, I might be in a better financial situation and I have bought a car, and I then decide to buy a parking space. I think it is a genuine need of a PR in Hong Kong. Now, if if a residential flat and a parking space are bought at the same time with different considerations, you want to charge doubled AVD for the parking space. Well, you have to be reasonable. You should not always oppose the public. The legislation is meant to curb speculation, rather, or is not to dampen people's desire to own properties or to deter people from buying properties. Now, I am sincere. I really hope that the law can be improved so that we can benefit our economy. While you want to plug loopholes using the bill, you have to ensure that the clauses are reasonable. I think that is the spirit of our remarks this morning. So please think twice. Ms. Abraham Sheck, to be followed by Mr. James To. Now, for your information, some property developers do not sell parking spaces when the flats are first sold, and then after a while, the parking spaces will be sold to incumbent residents. So, in fact, it might be easier if both flats and parking spaces are sold together in the same assignment. Now, if after a while parking spaces are sold to the residents there or owners there, will they have to pay that double AVD? It's for their own use. Anyway, I asked the DS to answer. Yes, I know they're going to charge doubled AVD, but that is not really reasonable, although it is legal. Now, the PR, who's an owner there, is already using the parking space, and he's going to buy it from the same development. It is not reasonable. I appreciate, I understand the scenario quoted by Mr. Bramshek. Still, the instrument is for buying the parking space, which is a non-residential property. So under the bill, the buyer is required to pay doubled AVD. Mr. James To, this is horrifying. You must clarify. Roman 2 here. Where the residential and non-residential properties are separate and distinct properties with their respective considerations separately set out in the agreement. I think the DS might be wrong when answering my questions in relation to Roman 1. But Roman 2 here is even more horrifying, assuming that the consideration for the flat is $10 million and $1 million for the car parking spaces, and they are separately set out in the agreement. So the total consideration is $11 million. The residential property can be exempted from the doubled AVD, but the stamp duty rates applicable will be based on the total consideration of the whole transaction. This is outrageous, because you are going to cover the consideration for the parking space as well. So it's 11 million. 11 million.
However, the non-residential property would only be worth $1 million. Then that's horrible. However, because the car parking space would be paid together with the residential property, and so it would be charged duty on the basis of 11 million. DS, can you clarify? Okay, making use of Mr. To's example, the residential property worth 10 million, the car parking space 1 million, so the total consideration is 11 million. That is the total consideration. We will use it to look at the duty rates for these two items. In other words, the car parking space would be charged duty on the basis of 11 million. Can you wait for the DS to complete her answer? We will apply the relevant duty rates in order to charge the two properties. Well, of course, I understand it, but the car parking space will just cost $1 million. So we are being so stupid if that's the case. I buy property for 10 million, and I should really separate the agreements for sale and purchase. But then a more common practice is to buy the two together, because the selling party will tell me to pay for both at the same time. If there are estate agents around, because of 1C2 in Annex 1, I believe under arrangement, this is something unknown to the estate agents. If they don't know it and you haven't issued any guidelines, then, well, it may be happening this minute. If I separate the agreement for sale and purchase, and I will be charged only the duty rate on the basis of 1 million for the car parking space. But if they are paid together, I will have to pay on the basis of 11 million. So are you snatching or robbing us of money? Okay, you are clear. DS, if in the same instrument there are different entries and they have different considerations, of course there will be one total consideration. Under the AVD system, that is how it is calculated. I know. But this is about DSD. DSD is to stamp the sale of non-residential property, and people have already included the different considerations. Unless people are playing foul, say the car parking space is worth $1 million, however they say it is just 10,000, then of course you want to take them to task. But if people are genuine, are law-abiding, you should not lump the car parking space to the residential property. Are you sick? That won't do. I give you a last opportunity to answer. You should go back and think about this. Or else, if this goes out, people will think that the administration is crazy. I thought I had read it wrongly, but DS, can you clarify? Chairman, when we responded to the Law Society and the estate agents, we also said the same thing. Did you remind them to remind their clients to pay for them separately? Well, whether it is paid together or whether two instruments are used, it will be the decision for the buyer. Under the AVD system, if some people put more than one property or more than one item in an instrument and pay stamp duty, then we'll have to look at it as one single transaction. That has been done in the past. You are just following past practice. However, the impact will be grave. According to your table, it should be 1.5%. That is AVD. But making use of Mr. To's example, it will be 7.5%. In other words, even the car parking space will have to pay 7.5% AVD. Yes, that's correct. But let me point out, this is what has always been done in the paying of stamp duty. Mr. To, can you please listen her out? Well, she has always been saying the same thing. Okay, please do not interrupt because you will have your time to speak. DS, if the buyer thinks that they want to use two instruments, it is really up to them. No, I'm worried that people might not be able to consider that point because it is a new tax and this is just being scrutinized. I'm not sure whether the estate agents can clearly explain things to clients, and they only know about the additional cost when they go to pay stamp duty. There would be quite some grievance. Well, you can talk about the arrangement again, but then I'm worried that people are not clear about this. Mr. To, my last remark. You have talked about this only today, and I have seen it only today. You said many people would have known it. Okay, I plead incompetence, all right? I'm raising this point. I hope other people will also speak up to tell me whether they also think that you are crazy. I'm talking about the administration, not the person. I'm talking about corporate craziness. Can the administration go back and think about this? Or are you telling me this is final? There will be no negotiation. We are just following past practice. But this is something new. The DSD is something new. can you be flexible? In other words, can you be a little smarter and adapt to the new situation? The DSD is something new. DS, can you go back and think about it? Or are you telling me that this is final, this is absolute? If this is the case, then you're really crazy. Okay, thank you. That point is clear, Mr. To. Any other members who would like to speak, who would like to refer to the examples in the annexes? The legal advisor. Thank you, Chairman. I have 2 questions. For the ILD, please. With regard to the scenario painted by Mr. To, even if there are 2 instruments, they could be regarded as a series of transactions, so that the consideration is taken as a whole. Is that the case? ILD? Thank you, Chair. You're correct. Even if there are 2 instruments to effect the transactions, that can constitute a series of transactions or a part of a bigger transaction. We have the power, depending on the situation, to decide on the tax rate, taking the consideration of the 2 instruments together. Sorry, I really need you to explain this then. In what circumstance will you consider this as a series of considerations so people have to pay higher AVD? Well, it depends on the facts of the case. In certain circumstances, that could be done on the same day. The 2 parties are the same people, and the transactions are done on the same day. And on the surface, there are 2 instruments, but one part necessarily entails the other, and it is considered one overall transaction. Now, if there are facts testifying to this scenario, then we can apply the principle of effecting tax rate on one single consideration. Legal advisor, about the replacement property, I'd like to clarify something. When you decide whether the property purchased is a replacement property, who will make the decision? Is it the person doing the transaction or the ILD? Say, for example, a father lives with his son. The property was resumed by government, so he doesn't have a property. But the son is an adult, and the father wants to buy property for the son because he's getting married. Both are PRs, Hong Kong PRs. And they buy the property jointly, so they do not have to pay the DSD, right? But after that, the father buys another property for his own use to replace the property resumed by government or otherwise. But since he already holds a property jointly with his son, if he buys one more, if you regard the jointly held property as replacement property, then he will have to pay DSD. But if you allow him to declare that this is the replacement property, then he doesn't have to pay the DSD. In actual operation, which property will be regarded as the replacement property? Is it to be decided by the ILD or to be declared by the buyer himself? The ILD can answer the question. DS? ILD. Thank you, Chairman. Basically, it is for the person paying stamp duty to say to us which is a replacement property, but he will have to comply with the stipulations in the bill that the replacement property must be purchased only after the original property is sold. And also, the original property and the replacement property must belong to the same category. But as to how this is actually applied, since there are no stipulations in the bill, we will not impose additional requirements to ask him to explain how the new property will be used. Thank you. Any other questions? Now, I'd like to ask something about Annex 1. No, we are talking about this paper. Sorry, let me ask the question first. Annex 1A, where commercial residential property A is acquired by a Hong Kong PR who is not a beneficial owner of any other residential property in Hong Kong. The arrangement can be exempted from the double AVD. So the old AVD rate will apply. That I understand, but I have some questions about the remarks column. In accordance with the definition set out in Section 20A1 of the SDO, the ILD will regard the property as residential property if part of that property can be used for residential purpose. In other words, regardless of the actual use. Is that right? As long as it is commercial residential, and even if it is bought for other purposes, it will be regarded as a residential property. Is that right? Chairman, we'll have to look at the relevant property and the relevant documents to see if any document will stipulate that at any time that any part of the property cannot be used as residential property. If that is not a condition that is present, then we'll regard it as residential property. Any other questions, Mr. To? Chairman, I'd like to go back to what I said. I don't know, I'm afraid. Maybe I used the word scenario and I misled you to give me wrong answers. I don't know, but let me look at C. Annex 1, Roman 1, and also Roman 2. It seems when you wrote the paper, you seem to be saying that if it is for the same consideration or for two different considerations, then they will be treated differently. In other words, the so-called inseparable transactions. I think you are not thinking of absolute scenarios I have in mind as in one. It's just that you bought two things at the same time and you cannot be exempted. In other words, it is not like I buy the residential property with one agreement and then I buy another one from another owner, or I buy a residential property and a car parking space from the same owner. Today I would buy the property and then suddenly I think I need a car parking space, so I also buy the car parking space. But once I buy both the residential property and the car parking space from the same owner, then one will apply. Is that right? Maybe I have got a complicated scenario. So when you say cannot be separately traded, it may be narrower than you originally construe. Mr. To, we already said very clearly what one would mean, and we answered the question. What is the question now? What is the difference from your earlier question? No, the thing is, when you say cannot be separately traded, maybe you should not go all the way. Again, I would paint a scenario for you. There is a unit which says in the DMC that it is paired up with a car parking space. In other words, it is 1 and 1A. And in other words, you cannot separately buy the toilet or the kitchen with another instrument, and at the same time you cannot separately buy the car parking space because it is included in the residential property, and that car parking space cannot be sold to 1B or any other person because it cannot be separately traded.
And I think, I know this is rarely done, but I've seen such DMCs. Perhaps you are not thinking something as narrow as that. Now, theoretically speaking, the parking spaces can be sold to whoever flats, to whichever flat, and then the parking space can be freely sold to anyone owning the flats there or even outsiders. So it's just coincidentally that flat 1A is tied with space 1A. And you think that under this scenario 1 already applies. Yes. Scenario 1 is a very clear-cut and straightforward case to prove that the two cannot be separately traded. They are linked. And then Mr. James To pose another example. Perhaps in the DMC they are not paired up. However, in selling the flats and parking spaces, the developer has decided that it is a linked transaction. Unless you buy the parking space as well, I'm not going to sell you the flat. It is a combination. So I think there should be documents for the ILD to consider, although it is not specified in the title or in the DMC whether the two must be sold together. Now I have added a lot of assumptions, but if there are very clear documents or provisions to prove that the two must be traded together in one single transaction, then I think it is proof for the ILD to decide whether the two should be considered together or separately. Now, if I am a second-hand buyer, okay, flat 1A and space 1A was sold already, and then the owner tells me that now if you buy this pair, I will charge you $11 million, and he will write me an instrument or a statement to say that. Can I use that statement and show it to ILD? ILD, please clarify. Thank you. I think we'll talk about two different issues. First, if in the same instrument there are two different things, should they be regarded as one? Should they be regarded as a residential property or a residential property plus a non-residential property? We will purely consider whether the two can be separately and distinctly traded. That is, whether land registry will allow the two to be split and traded separately. And that will help us to decide the nature of the properties traded. And Mr. James To is referring to another scenario. If at the point of sale, the two has to be sold, has to be traded together, then we'll regard it as a series of transactions. Now, if you buy this, you have to buy the second one, then the two transactions will both be regarded as part of a larger transaction, and the overall consideration would be used to decide the rate to apply. All right, that is, even if you buy a $1 million car park, $1 million car park, you have to pay 7.5%. And then, what about using one instrument to buy more than one property? I'm very concerned. Could it be possible that a person has never been the beneficiary owner of a property and can be regarded as having purchased one single property and can enjoy the old rate? It depends on whether he is the beneficial owner of another residential property. Now, for whatever reasons, he buys 10 flats in one go. That would be regarded as one single transaction. The old AVD rate will apply. However, we will use the total consideration of the whole transaction to decide the AVD. why is your thinking like this? I have never bought any property for whatever reasons. I go to a residential development, I decide to buy 10 units. Then do you have to check whether it can be the units can be sold separately enough for I don't know why he has enough capital to buy 10 units, but will 4.25% apply? Well, Chairman, you have reviewed a big loophole. Things are in a mess. I don't know what other members think. Other members, including Mr. Abraham Sheikh, well, he's a gentleman. I may second guess his belief. He may believe that this is a very good arrangement, but I beg to differ. Now, if you haven't owned any residential property and you buy one flat, I can give you exemption. If buy a second, you are not entitled to the exemption. But you have enough money to buy 2 or even 10 or 100 flats in one go. And you say that because you've never owned any property, now you can buy an X number of properties, and yet you still don't have to pay doubled AVD. So the old rate applies. How can that be the interpretation? The commissioner talked about the coupling of a flat and a parking space. Now, for Taikoo Shing, all the flats can be traded separately. Now, if I buy 1 or buy 10, it doesn't matter. I will pay the highest rates. But how can you give exemption? This is unimaginable. I can only say that you are using your very old technical thinking, and you have come to a dead end. So a flat plus a parking space rate is 7.5%. And then you buy 10 Taikoo Shing flats, 100 Taikoo Shing flats at the same time. That's still regarded as one transaction. This is unimaginable. The community will query, what is the spirit behind your thinking? What is your rationale? Is it really so difficult? I really cannot understand your rationale. Can you please elaborate? The commissioner said that this is one single transaction. No, you have to amend the arrangements because this is against your policy intent. Ms. Andrew Leung speaking for the first time, and Mr. Wang Ting Kwong second time. I don't own any property. Now, for instance, if I don't own any property and IFC is for sale, and then I buy the whole development, and there are many things included, and you regard it as a series of transactions, and let's say I don't own any property, but I've purchased a replacement property. Anyway, I buy a company, and I use that company to buy a series of properties. And the loophole under the replacement property arrangement has a big loophole. So what do you intend to do? When we vetted the 2 very draconian measures, SSD and BSD, the policy was okay. But when it was translated into legal provisions, there were so many loopholes. While we are against the BSD and SSD, well, people have different reasons for objecting the 2 measures. Now, if you buy 1 flat, I can exempt you from double AVD, that's okay. But sometimes a residential flat has to be traded together with the parking space, and you don't allow that. I think the law departs from the usual practices in Hong Kong, so you really have to think twice. Mr. Wong Ting Kwong. The two stamp duty bills, 2012, 2013. Now, we will not talk about the policy objective anymore. That's clear to everyone. Now, the overriding principles are to offer exemption to PR in Hong Kong and also a first-time buyer in Hong Kong, and also to give exemption to replacement property. I think B was proposed by member first. Now, if I am a first-time property buyer, I want to buy two small flats for them to be merged into one for self-occupation. How should that be dealt with? This is a very real case, and I've got friends and relatives doing the same. And so you have scenario D in response. However, this has also created a very big loophole. We are not talking about someone who buys two flats and merged them into one for self-occupation. Rather, what if I buy all the flats in one building? So it is a big transaction between a developer and a property agent. And I think if you exempt such transactions, it is entirely opposite to our policy intent. Not only that you can't curb speculation, you will be fueling speculation as a result. You will be fueling speculation of many flats in one go. Those who have enough capital will make use of this loophole to speculate flats in a wholesale manner. Mr. Hebramchek. Now, may I reply to Mr. James To's comments? He said that he was only second-guessing my intention. Now, as legislators, we have to ensure that the law is reasonable. I think the bill was introduced in a rush to tackle a pressing situation in society. The intention is to curb property speculation. However, you cannot make use of one bill to address all possible scenarios. You can't really address different situations with only one bill. And you should not also crack down on very ordinary market behavior. I think many people are already doing this. People use one agreement to buy 6 or 7 flats. I think this is different from your policy intent, and as legislators, we don't believe that this is fair. As Mr. Wong Ting Kwong said, or rather in 2012, Low Ing Lok said that the law must be both legal and reasonable. You must not be so blind as the last stamp duty bill. This one is already more humanitarian.
Okay. Yes, I understand that you are just explaining the bill as it stands, but with regard to 1D, I hope you will give it serious consideration. My observation is, and as members have said, they are worried that this will become a loophole. That's the first thing. Secondly, if that is really the case, then to be fair, this goes against your legislative intent. If this is allowed and is used on a large scale, it is not going to be an ideal situation. And secondly, Some members have already said clearly that they object to the bill, but even for those who support it, they are asking you to consider how the genuine need to buy property of the citizens will not be affected. And it's not just this part. Think about car parking spaces. And the business sector members will also mention the self-use buying of property, or else there will be a big barrier to the passing of the bill. The legislative intent is to suppress speculation and cool the market. We all agree. But as it is written, the bill will really do something negative for people's genuine need, whether they need property for self-occupation or the business sector. Please think about this because we are now studying a bill of 2013. I think this is the most controversial part because people's livelihood is affected. It is all right for people to self-occupy the flat, there is exemption, but car parking spaces is the problem. I believe you really have to consider that. Any response? Chairman, thank you for giving me the opportunity to give a brief response. Since we are already at clause-by-clause examination of the bill, the focus of the bill is really to distinguish between residential and non-residential properties. The scenarios we have considered while drafting the bill has been listed in this paper, and it is a technical discussion to facilitate clause-by-clause examination. Chairman, you mentioned this as a policy. After we have completed clause-by-clause, after we have looked at all the technically related scenarios, then after listening out to members, we will of course explain the legislative intent, or we might like to improve the clauses if necessary. Just now members really mentioned car parking spaces and also the transaction on several properties in one instrument. I think members have been very kind. Now, first of all, we have to pay attention to the instrument-based AVD. That's the premise. Secondly, we also have to look at the policy intent. What are we trying to deal with so that we want to have DSD? But when we come to residential or non-residential property or more than one property, then definitely there will be a balance between applying different duty systems. I think some members have put the fingers on a very important point. In other words, if an instrument includes the transaction of several properties, then in fact the starting point of the entire policy is also to take care of the housing needs of Hong Kong people, and of course the premise is whether they already own residential property. Some people really need to buy more than one property for genuine needs, and that is possible. And after balancing that situation, we have no intention to impose heavier duties. But if we push this to the extreme, if somebody buys a huge number of properties with one instrument, well, we have reviewed the instruments. We haven't seen a lot of these. So in the end, it's a balancing act. The policy intent, the taxation system, and also impact on society. Car parking space is a special category in non-residential property. It is related to residential property, but in certain cases, people just buy a car parking space as investment. We'll have to take a closer look. I have listened to members, and we will precipitate our thinking and share that with you later. But when we go through clause by clause, I'm sure there will be more opportunities for exchange. Mr. Wong Ting-kwong. Thank you, Chairman. DS, you said there has not been a big number of those. However, the impact is great. You have to consider this. There are laws, including criminal laws, which target a very small minority of criminals in society. So don't tell me there is a small number and try to say that this is not a big loophole. I hope you won't use that kind of language, because if this goes out, you will be lambasted. Secondly, don't make use of the clause-by-clause examination of the bill to try to stand firm on your policies. Well, we have already passed the policy discussion stage. We are now at clause-by-clause examination. And therefore, we are looking at specific cases and the details, and then we have found this and that kind of problem. We have no objection to the legislative intent, but when it comes to the details, we want to improve the bill. Therefore, many members have mentioned this and that kind of different scenario for your detailed consideration and study. That is why we have mentioned our thoughts with you, hoping that you can take them on board. When we advance further in the scrutiny of the bill, I hope that you have listened to us. You would consolidate those views, and please do not reject them right away. If you think some of them are feasible, meaningful, and if they align with the legislative intent, then please move your own CSAs, and the committee will certainly support you. Whether it be stamp duty, A Bill 2012 or 2013, we want to stamp out speculation, but we don't want to disturb the public's need to buy property. We don't want to destroy the economy either. We want the economy to develop on its right track and people can live and work happily. We are just here to suppress speculation. That's the entire legislative intent. Therefore, if you do not achieve the purpose of suppressing speculation, and if you act as a disturbance to the public and also you affect the economy, then I'm sure members would have to give detailed thought to the bill. I really would like to issue this kind reminder to you, and I am keeping a cool mind when I say that to you. Mr. To, on the same part, para 8 at the end. Each of them can be exempted from the double AVD for making one replacement purchase. In view of this discussion, I'd like to clarify this one replacement purchase. If it is an individual, the replacement property would include 10 Taikushing flats using one instrument. Is that the case? Is that possible? Mr. To, please repeat. Are you talking about replacement property? Yes, because near the end of para 9, you say, in addition, the replacement property and the original property must belong to the same category. That is one residential property to replace another residential property, blah, blah, blah. When you say residential property, you mean one, but however, you are using the concept of one instrument. That's what I heard. Does it mean one replacement property does not mean one replacement property? Or is it that in this part of the bill, you are being accurate? In other words, one means one. Instead of my property or my sport property in Kuntang of 300 square feet has been demolished, so I can buy 10 Taikushing flats using one instrument under my own name. Could that be regarded as one replacement property for exemption? Chairman, the provision for replacement property is in 29 DL, but we haven't come to that. The diction there is very clear. It expresses one replacement property only. And Mr. To, actually, the other part would apply to those who haven't owned any residential property, but replacement property buyers would theoretically be people who have owned property. But please clarify. Well, yes, I am asking about the difference in diction, if any, in the two governing provisions. The legal advisor, please take a look for us. And please remind us of this when we come to that clause. I'm afraid I may forget it. Okay, let's wait until we come to it. And then para 9. One residential property to replace another property, etc. Let me give you an example. If a residential property and a car park have been resumed, they are subject to separate agreements for sale and purchase. Well, this happens even with old residential properties. Now, does it mean then my replacement property would be just one residential property and a car parking space, or one residential property plus one non-residential property? I don't know whether this is possible. Let us look at the wording. If a residential property and a car parking space has been resumed, can I buy one residential property and a commercial building worth $3 billion? Right? So you resume one residential property and one non-residential property. I can buy one residential property plus one commercial building. You can say a commercial building does not equate a car parking space, but then you're only categorizing them as residential and non-residential. So the car parking space is non-residential, and I can very well buy a commercial building in the place of a car parking space. Is that possible? DS, in 29AL, exemption for replacement property, there are very clear provisions with very clear wording. We must stick to 29AL when we paint different scenarios. Well, but do you know the answer? If you say no, then I would be reassured, at least for a few days. But when we say, or when you say you have to take another look, then we will really have to discuss it. I have to remind members that we have already visited 29AL. Why don't you make use of the wording in order to allay members' worries? Can I defer to my colleague because he has turned to that page? Okay. According to the bill, 29AL stipulates certain conditions. Please refer to bracket 3. A. The person has to dispose of the original property before he can buy a replacement property. B. The two, in other words, the original property and the replacement property, are both residential properties or both non-residential properties. They have to be consistent. Chairman, those who have a residential property and a car parking space, now the car park is a non-residential property. That's the concept, isn't it? Then that will be unfair to those people. I don't get it. Or do you allow people to choose? You can buy a whole building, a commercial building worth $3 billion. Is that right? Because as it is written, the concept is that it must be residential or residential, but that's not the case.
But take the example of the railway. There was a whole building resumed in Kwai Chung for the construction of MTR. So it was an industrial building, but with parking spaces, and also residential developments can also got parking spaces. All right, assuming that one residential unit and one and a car parking space were resumed, how do you consider? We will consider the nature of the property. Our view is, if one residential property and one non-residential property are resumed, then in principle, in replacement, one residential property and one non-residential property can be purchased as replacement. However, it's not appropriate to speculate on the details. So the principle is, if one residential property is resumed then or acquired, then a residential property can be purchased in replacement, and a non-residential property purchased to replace an acquired non-residential property. No, you can't do that. We are scrutinizing the details. 3B says,
or both non-residential properties 嘛，咁即係其實你冇諗過一個情景係會有第。
That means you have never contemplated a third scenario where you have both. Perhaps you adopt the predominant test, I don't know, but please give us a paper to explain this, because this involves whether we're going to amend the bill or not. Yes, we can use a paper to supplement. Yes, please. Legal advisor, please give us your legal observations at the next meeting as well. Mr. Lam Tai-Fai, the first time. I'd like to seek clarification on one item, BSD or DSD. Now, assuming that I have a company, a Hong Kong company, and I'm a minority shareholder of a Hong Kong company. The company holds a residential property never inhabited by any of the shareholders. It is for overseas employees. And then one minority shareholder, as myself, goes out to buy a residential property. I've always lived in leased premises, and now my company holds a residential property and I go out to buy one myself. Do I have to pay a doubled AVD? No, because a company is a separate entity. We always say that a company is a corporate person, a separate corporate person. All right. If I am living in my own residential property and I use a company to buy another property, well, the two are separate. So however I purchase it under my company's name, your company has to pay. No, I'm not referring to BSD but DSD. Because the company is not a PR in Hong Kong, so the company has to pay DSD. Yes, because the company is not a permanent resident. We have some outstanding issues, including the paper or the part on a transaction or transfer between close relatives. I'd like to complete the discussion of this paper so that the government can know our position and consider possible changes. Mr. James To, well, I have too many questions on the issue of close relatives. All right, let's discuss this to see whether it is the government's final position. Mr. Lam Tai-Fai, go back to my previous question. If the company holds a residential property and it's never been lived in by any of its shareholders but by its employees. Now, if the property is being occupied by shareholder A, and shareholder A wants to buy another property for his own use, will he have to pay DSD? No, even though he lives in two residential properties, he doesn't have to pay DSD. Well, the basis is who is the beneficial owner. It doesn't matter whether you live in it or not. Speaker is off mic. All right, this is clear, Mr. Lam. Is that clear to you? Okay, Mr. James To. According to the administration, well, we raised some possible abuses involving replacement property, and according to the administration, the chance of an abuse is very low. But what about close relatives? You know what is our concern. The father and son and daughter-in-law, a very typical nuclear family. Why do you require each of them to be close relatives? What about members of recognized nuclear families? Why can't the members enjoy the exemption. I cannot fabricate a close relative. I can't ask my son to marry a lady, and then after the transaction, I ask my son to get a divorce. In 2011, or rather in 2012 bill, we talked about a possible divorce or bankruptcy of close relatives. I think at the same token, it's not easy for you to find someone terminally ill and ask him to write a will. Well, in 2011, you bought our argument. So can I be brief? Can you think of possible close relatives or recognized nuclear families and offer exemption? Can that be done? And I think the same was requested by Mr. James at the last meeting. I'd like to know whether the administration has considered Mr. James To's proposal, and this is your final position. Because you say that you would like to uphold the current practice. I think Mr. James To has a point, but can you please tell us whether this is your final position after consideration? If I may answer Mr. James To in this way. The definition and scope of close relatives can be found in both BSD, SSD, and DSD. So we are using the same scope. Mr. James To, well, just quoted one example of, the transfer from parents to their son and their daughter-in-law. I think we must confine the scope of close relatives. In DSD, now, if names are added and if they are close relatives, well, in Annex 2, we have provided an example. The last example in A. Under such a scenario, now if the son, regardless of whether he is a PR of Hong Kong or not, or whether he is the beneficial owner of a residential property, the instrument will be considered using the old AVD rate. Now, if the flat is jointly owned by the wife and the son, now because the daughter-in-law doesn't fall into the definition of close relatives, she cannot enjoy the old rate. However, if the wife is a close relative of the son, and if both are not beneficial owners of other residential properties, they will be regarded as the same. And so then they can, and then the instrument can be exempted from the doubled AVD. And according to the IRD, the instrument will not be required to pay doubled AVD because the wife or the daughter-in-law is not a close relative. No. Now, for the addition of a name, well, I think half of the stamp duty amount is required. All right, transfer from parents to their son. Now, if the consideration is 1 million, then the stamp duty is paid once, and if the son would like to add the name of his wife, then half stamp duty applies. According to Schedule 1A of the current stamp duty ordinance, there is a footnote. If the person is a close relative and then the name is to be added to the agreement, then the agreement is exempted from AVD. the addition of the law. In fact, there is a transfer of half of the ownership to the wife. You mean the instrument or the agreement is exempted from AVD? Yes. My understanding is it's not possible. Is there any restriction on the time for that to be done? For nomination, it's okay, but if it is not nomination, rather a transfer, I don't think that's the case. Yes. That is only possible in a very highly specified situation. If the name is to be added to the agreement before the actual assignment, then that agreement is exempted from AVD. This is under the current AVD system. So you are saying that because it can be done through this, then no exemption is needed. Now, let me quote an example when this will not work. In this case, the wife or the daughter-in-law must not own any property. Now, if the elderly parents wants to transfer the property to the young couple, now the wife might own half a property together with her parents, and then the exemption cannot work. Exemption is so important because this is a nuclear family. When the elderly couple transfer the property to their son, exemption should be granted. You don't have to ensure that none of the younger couple owns any residential property. You have to understand that this is not about buying property from the market or speculation that few property prices. You have to be short, Mr. To, because another member has raised his hand. No, you should give them exemption because this is this kind of relationship is already very common in a nuclear family. All right, Mr. James To talked about close relatives. All of them are close relatives. They're close relatives to one another. For transfer between close relatives, you don't have to consider whether any of them owns properties or not. Yes, in general, regardless of whether the transferees are PRs of Hong Kong or whether they are beneficial owners of any property in Hong Kong. Now, Mr. To, I'd like to tell you that we're not using this case to say that we can't consider Mr. James To's proposal. I have 2 points. Whenever we talk about the circle of close relatives, we face we have heard similar arguments or scenarios. You can't really address each and every possible scenarios. I was using that scenario or case for Mr. To's information. We already have exemption arrangements when it comes to exemption of AVD for transfers between close relatives. I'm not using that as an example to justify why I won't accept Mr. James To's proposal. Mr. Lam Tai Fai, if a person owns 3 residential properties, ABC, and he has a will, and the properties will be given to a close relative, another one to a non-close relative, and the third to a corporate body.
But he doesn't know whether the company owns any residential property. In any case, he is dead and he wants to give it away at no value. I'd like to ask about these 3 persons, the close relative, non-close relative, or the company. Do they have to pay DS? Mr. Lam, you're talking about a person who has passed away and he is transferring the property through a will. Let me tell you the general situation and the principle. Under 27(5) of the existing stamp ordinance, there is provision for transfer of property for people who have passed away. Usually the AVD and the DSD would both be exempted. But Mr. Lam also sought to point out the transfer of property to other people. No, I'm not talking about transfer. I'm talking about giving it away at no value. The person dies. He has A, B, and C properties. He wants to give them away to 3 different people at no value. 1, a close relative, 2, a friend, and 3, a Hong Kong company or a charity. But the person making the will does not know whether these 3 properties already own property. That's how he writes the bill, but then the situation may also change after his death. He doesn't make the will on the day of his death. So will I actually be doing a disservice to these people because they have no money to pay the DSD? Well, basically, there will be exemption. Is that right? This transfer as a class, if it is according to a will, saying that it is given away without any value, then according to 27(5), there will be exemption of AVD and DSD. Aren't they the same? Are you talking about BSD and DSD? Yes. You don't even have to consider whether those parties already own property. Because, when I make the will, I don't mean me, but I mean person A. He wouldn't know. Those beneficiaries would already own property. AVD, BSD, and DSD are exempted if there is transfer according to a will. Okay, there will be exemption. There will be no consideration of whether the beneficiaries already own property. Mr. Ibrahim Shah, really, you are the last one. We have exceeded the time. Thank you for clarifying Mr. Lam's query. Say, for example, I'm a beneficial owner. But under C, you say beneficial owner of any other property. You say if my company owns the property, I can still buy property under my own name. But I also am the beneficial owner of the company. You understand what I mean? Company A may hold 3 properties. I am a beneficial owner of Company A. It is a legal entity. But companies also have beneficial owners, right? Are you following me? Can I clarify that? Then I also, the company holds 10 properties. I'm the beneficial owner of that company. I am a minority shareholder. And now I decide that if I don't need to pay DSD or BSD, I want to buy property using my own name. I just like to clarify that for the sake of the public. I can clearly express that a shareholder of a company, he may own some beneficial interest, whole or in part, but the company in the capacity of a legal entity owns a property. Then in law and at the land registry, the company is the beneficial owner of the property. That will not impact upon individual shareholders who would like to buy another property in his own name, because we have separated the definition of companies and individuals being beneficial owners. In other words, shareholders are not affected. When you say beneficial owner of any property, but I am a beneficial owner also through the company, I'd just like you to clarify that point. Please clarify that. Well, Chairman, we don't need to revisit the bill of 2012, but then the whole premise is that we separate companies from individuals. A company may own property and a person may own the beneficial interests of a company, but those are matters at two different levels. We abide by that principle, so I can give a very clear answer to the member. There will be no impact according to your scenario. Now you're clear, right? Shareholders can still buy property in their own name even if their company owns property, because they will not be regarded as the beneficial owner. Okay, Mr. To has left, but I'm sure the DS knows his viewpoints very clearly. I'd like to confirm with you that this is your final position. Well, yes, as it stands. The crux of the matter is whether you'd like to expand the exemption. Well, but then we are very clear that when we tackle BSD, DSD, and we should align the arrangement for all close relatives. We believe we can now strike a balance between the policy intent and the careful execution of the exemption. Okay, that's it on this point, because we have visited it many times. I think we have had a very sufficient discussion of the paper. We'll go back to clause by clause next time. DS, you have promised that you will speak more on D in Annex 1 and also car parking spaces. That's the end of the meeting today, Mr. Adjourned. Thank you. Sorry, I need to announce the date of the next meeting. The 28th of March. A notice will be issued. It's the 28th of March.